Welcome, everybody. I'm Ben Cushing, your 2023 NHAR president. And by now, you've probably heard the lawsuit against the National Association of Realtors that has recently been ruled on. So we're joined by NHAR legal counsel Matt Johnson here today to help us understand the facts of the case and what it might mean to us as realtors. So Matt, thanks very much for joining me. It's greatly appreciated as always. And could you give us a synopsis of the case and how the court ruled on this case?
Certainly. So this was a class action lawsuit filed in Missouri Federal District Court. And so the class action alleged antitrust violations. So a conspiracy between the National Association of Realtors and large corporate brokerage firms to enforce the cooperation policies in NAR and MLS. And that the argument was that those policies artificially inflated the commission rate that buyers and sellers of real estate in the United States would pay. NAR hotly contested those facts. This rule has been in place for a long time and had vigorously defended itself, as did the remaining corporate defendants. Two of the corporate defendants settled out before trial. The trial commenced 3 weeks ago, give or take. 3 weeks of trial. Plaintiff put on evidence, defendant put on evidence. After 3 weeks of trial, the jury deliberated for a grand amount of time of 2.5 hours and came back with a verdict. There was a 4-question verdict form. The jury found in favor of the plaintiff on all four factors, all 4 questions. The verdict amount was $1.78 billion. Under our antitrust statutes, that amount gets trebled, so it's 5.4 and change billion dollars is a potential verdict. This is very much that sort of in a nutshell is where we stand procedurally in terms and just substantively. It was an antitrust violation finding by the jury.
So it sounds to me like there's still so many moving parts to this and still a long way to go. What might be the next thing that could occur in this particular case?
I do have to stress that this is the very beginning of this dispute. I don't know if you want to use a baseball analogy. I would say it's probably in the 3rd inning. So the verdict has been reached. NAR and the corporate defendants will file what are called post-trial motions first with the trial judge. Some of those will include asking for a new trial because they believe that the evidence presented was not sufficient, and also there are some legal rulings that happened that they think were incorrect and were prejudicial to NAR and the corporate defendants. So that will happen. Following that, if those are not successful, they will undoubtedly appeal the case to the 8th Circuit Court of Appeals. That's probably a 1.5 to 2-year process before the 8th Circuit Court of Appeals would render any judgment. And then for a case like this that is dealing with sort of unique antitrust laws, and antitrust isn't something that gets litigated all the time. Either side, whoever doesn't win the 8th Circuit Court of Appeals could petition the U.S. Supreme Court to hear and rule on the case. The U.S. Supreme Court does not have to take the case, but this would be the type of case, given the amount of money involved and the industry involved and the sweeping impact of it, that I would be surprised if the Supreme Court didn't take it if the matter went up on appeal, and that would add a year or two as well. So you're realistically probably talking 3 to 5 years out before there's any actual final judgment, and the final judgment may not look anything like what the current jury verdict is.
So with all that said, what are some of the things that the National Association of Realtors are using for argument on their side in this case?
Great question, Ben. So NAR has long argued and presented evidence before the jury of the pro-consumer benefits of the cooperation model. This is not a new rule. It wasn't just passed. It's been on the books for a long time. It has been the linchpin and central foundation to the U.S. real estate market. NAR argued and had evidence to support that it provides a pathway to home ownership. It is most protective of low-income families and low-income buyers. It allows families to buy property and create generational equity because the model lowers barriers to home ownership. So NAR has been a staunch defender of the model and has had expert testimony and fact-based testimony of why the rule went into place, why it's been beneficial, why it's pro-consumer, and why, importantly, the commissions are always negotiable, and the commission rate is a bilateral discussion between the seller of property and the listing agent, that there is never any conspiracy, and that for each transaction is unique, and for each transaction, the commission could be negotiated. So NAR was very frustrated with the fact that it appeared as if the jury did not consider any of that strong and compelling evidence.
And finally, Matt, what, if anything, should our members do differently as they continue to work in real estate as a result of this ruling that came down in St. Louis?
So the good news is the agents and brokers in New Hampshire really do not need to do anything differently. This is not a final ruling. This does not require any change of conduct. What I would encourage agents to do is remember their antitrust obligations. And by that, I mean, remember that when you're speaking with a new potential listing client, you don't want to automatically fill in the commission percentage. You want to be and make sure that sellers know that that commission rate is negotiable, and it can be discussed between them and a rate set that makes sense for the seller and the transaction. You want to make sure that that agents and brokers are not talking outside of their own firm about rates, or setting standard rates with any other firms, or publishing schedules of rates, or doing anything to suggest that unless a seller agrees to a certain rate, they won't get enough activity on their property. So it's all stuff that agents should be doing now, but just with the spotlight on the industry, the rule is pro-consumer, but it's pro-consumer when it's used the right way and reinforced the right way. So make sure and take the time to do the proper discussion with the buyers and the sellers. Continue to do what you're doing, but just be mindful to ensure that everybody knows it is all negotiable and it is all transaction specific. And if you do that, then keep doing what you're doing. Nothing needs to change.
Well, that's good. Disclose, 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 right?
Absolutely.
Matt, thank you. Thank you as always. We greatly appreciate you joining us, taking time out of your day. And I'm sure we'll be back on here as things continue to proceed with these cases. We'll have you back on. But everybody, please stay tuned for further updates as this all works way through the legal process. We appreciate Matt as joining us as always, and wish everybody a good day, and keep disclosing as we're supposed to out there. Have a great day.